You're here today for sentencing in this case. This case involves a conviction for a drinking and driving third offense, which is a felony, plus there's a second habitual felony offender enhancement. Mr. Deadhound, do you have any amendments, corrections, or objections to request as to the PSI?
Thank you, Your Honor. I have reviewed the PSI report and I have no those corrections, additions, or omissions.
Same question, Mr. Champion.
Could I have just a moment, Your Honor?
Certainly.
We have no additions, corrections, or deletions, Your Honor.
Okay, thank you. Allocution.
Your Honor, this is a very unfortunate situation with Ms. Wheeler. Without question, she has several convictions for operating while intoxicated. However, in meeting with my client, which recently she's come to understand after regularly meeting during the time of incarceration with both community mental health and Catholic Human Services, that the underlying issue that she has been not recognizing is the fact that she consumes alcohol as a way to treat issues in her life. She has had severe trauma since a small child. Whenever something major happens in her life, is basically the only time she consumes alcohol, and then she drives and gets arrested. She recognizes she has a severe problem and she needs to address that. So the court's aware. My client is attempting to get into a treatment program. She's currently accepted to a program in Saginaw that will address the underlying mental health issues along with her substance use to medicate those mental health issues. With that, given our guideline from 7 to 28, I would ask the court to consider term with release to treatment so that she can address for the first time that she's recognized the fact that her underlying issue is a mental health concern. Thank you.
Mr. Deadhound, on behalf of the people, sir.
Your Honor, the recommendation is for the top of the guidelines, a minimum of 28 months. I would argue that the court has even grounds to exceed that minimum. So I certainly support the recommendation. Unfortunately, nothing has worked with Ms. Wheeler. The last OWI third conviction stemmed from an incident that occurred back in 2023. In that incident, the defendant rolled her vehicle over. It landed on its roof. A very serious incident. The defendant has gone through prior treatment. In fact, from 2016 to 2018, she was in sobriety court. In this case, she had just been off of a parole from the last prison sentence for approximately a month. She has 8 prior OWI convictions in the last 11 years. When law enforcement went out there, she was in this incident. She went out to the vehicle. The vehicle was still running, and the test results were exceedingly high, 0.178, 0.179, and I guess also concerning is that she indicated that she wanted to kill herself, which is one thing if an individual wants to kill themselves, which is it's bad enough. I don't want to downplay that by any means, but when they're doing an act that potentially could kill others is also concerning. So clearly a very serious risk to the public. So I fully support the recommendation. And with that, I would ask that the court sentence the defendant to at least 28 months, Your Honor.
Thank you. One moment. Ms. Wheeler, is there anything you wish to say today?
She stood in court and admitted she abuses alcohol, blaming trauma that started when she was 4. She asked for treatment and said she wanted EMDR therapy. Then the prosecutor dropped the number, 8 prior DUI convictions in 11 years, and this time she was just 34 days off parole with a .178 BAC. The judge didn't debate anymore. He sentenced her to prison and said she should never touch a steering wheel again.
Yeah, I'm not very good with this.
It's okay. Take your time.
Your Honor, I failed to admit in the past that I have an alcohol problem and that I abuse alcohol. some severe trauma issues that I have gone through since I was age 4. This is not something that I discuss with people. But unfortunately, since I was 50, this is how I coped. But since being incarcerated this time, I have realized with the help of CMH and CHS that I need psychological treatment for the alcoholism and the severe trauma that I've endured. It has been suggested that I go to the EMDR therapy from Catherine and Christine, and I'm hoping that I have the opportunity to work on that, Your Honor. Thank you.
Thank you, ma'am. Well, defendant is 59 years of age. That tells me we have somebody who is old enough and experienced enough to understand making some correct choices, what happens when we make bad choices. And when I look at this particular case, one of the things here that I note is there was a report to law enforcement for a be on the lookout for a vehicle being driven by the defendant out on M42, which is one of the most heavily driven roads in Missaukee County. And then over on North Blodgett Road, also another major road in this area, as major as a road you can call one in Missaukee County. The blood alcohol level here was significantly high at 0.178. And the timing is terrible. The defendant had just been discharged from parole on September 5th. Occurred 34 days later. So you start to wonder how bad are major events. Just got off of parole. Well, criminal history began in 2015 with a drinking and driving. That was 10 years ago, so she was approximately 49 years of age. So these crimes have all been combined within about 10-year period of time. Now, in that particular case, she didn't get probation. She got 45 days of jail and some fines and costs. And it took 1 month later before she got picked up on another charge. I will note that that charge was dismissed. But after it was dismissed, another month later, so we're actually only 2 months out from the sentencing for case 1, that she picks up drinking and driving number 2. Now, she was charged there with driving license suspended, and while that count was dismissed, I can make a reasonable deduction that because of a drinking and driving, there are some automatic license suspensions. She had no license. So she violates probation. I'm sorry, didn't violate probation, but she violated once again, going back to the same misconduct of drinking and driving and putting people at risk. Now, thankfully, there she got probation. That probation began on October 14th of 2015. Now, while that case was pending, she violated bond. Now here, because that last case that I just mentioned had an arrest date of August 16th of 2015, she makes it 15 days before she violates bond. How does she violate bond? Drinking and driving. I'm curious as to what major events are all happening back to back to back where she can't stay off of the booze. Regardless of what they are, all I am learning is that you can't make good decisions. Now, when you got placed on bond, again, a probation, again, this other case, you also, it's your 3rd drinking and driving within 4 months, 5 months. You get probation on 2 files. You were on that probation from October of 2015, and you make it 7 months before you violated it. And you had to be put on sober lane. Then there was another issue. In fact, you even got 15 days in jail. When those 15 days were done, you got another bench warrant and you had to be sentenced again. Within 8 months of being on probation, you violated it twice. So count entry 5 of 10 here in your history. You're on probation. This is where you picked up a driver's license suspended, meaning you can't comply with bond, you can't comply with probation, and you can't comply with the laws that say don't drive a car. Now here in this case, you were convicted on March 28th of 2016. You made it 3 weeks for violating probation again and picking up your 3rd drinking and driving. And it looks like you were placed on a delay of sentence and given the opportunity to sobriety court, yet you struggled with it. They said you successfully completed the program. I don't know how, based upon what I'm seeing in here, but they gave you a completion of the program. Well, if you completed it on July of 2018, you made it 11 months. So far, that's the longest you had made it in the last 3-4 years. You made it 11 months before you picked up your next drinking and driving. So I think right now we're on number 4. And this results in a plea and a conviction. You get probation, and you did receive an early discharge from probation. You were compliant. One moment. Wait a minute. Oh, I see. Disregard. Yeah, so you got an early discharge from your probation, and you celebrated with picking up your next drinking and driving a few months later. Plus, you're driving a car when you have no license. You should never, ever drive a car. I don't know how you're getting access to cars. I don't know who is letting you have the keys. I would wonder if these cars are licensed. Do they have insurance? It's funny because if you're out paying for insurance and paying for registration on your own vehicle, that's crazy. But if you're taking someone else's vehicle, I want to know how'd you get their vehicle. You should never, ever drive a vehicle. Your days of driving for the rest of your life are most likely, because I'm not in charge of licenses, the Secretary of State is, you should never, ever have a car in your name and never, ever touch the steering wheel. All right, so 6 months later, now we're in October 2021, you pick up your next drinking and driving. Now you've even got alcohol opened in the vehicle while you're driving. Your probation was terminated by me unsuccessfully. Then after that, I'm sorry, while you're on that probation, and I terminated you unsuccessfully because you only made it 9 months before you picked up your next drinking and driving. On that one, you pled no contest. I have to assume that would have been because of how drunk you were. Then I gave you prison, 18 to 60 months in the Department of Corrections. You get out, you get parole, you're discharged from parole. 34 days later, drinking and conviction number 8. Court assesses a $68 state minimum fee, a $130 crime victims' rights fund fee, a $300 court cost. They don't need to do a DNA fee, a $300 attorney fee. Now I'm going to go back for a moment here. And I don't typically do this, not a lot of people pay the fines and costs and stuff. And there's a lot of philosophies or theories out there from other judges about, well, do they pay them or not pay them? Do they still get put on parole? I'm going to tell you, if you're able to drive a car and somehow pay or have access to a car, I think you can pay your bills. I'm going to assess a $1,500 fine. Supervision fees, no, because we're not doing any probation, that's for certain. This court sentences the defendant to a prison term of 28 to 90 months. I exercise the discretion to sentence her as a second habitual felony offender. And the court gives her 106 days of credit. This is not like a case where somebody gets one, does a probation, tries, goes to some AA, does stuff. This is a person that has, might get 3. This is 8 drinking and driving. It is now prison time for you. And that seems to be where you want to go. All right.
The judge read her history like a countdown: DUI after DUI, bond violations, probation failures, sobriety court, even prison time, and it still kept happening. He said this wasn't a one-time mistake, it was a pattern that could kill someone on a major highway. Then he hit her with the top of the guidelines and a second habitual enhancement. His message was simple: the court can't keep taking chances when the public is at risk.
Thank you very much. I'll note that you, Mr. Champion, has just provided to me a piece of paper that has your initials on it. It is a copy of the notice of rights to appellate review. You have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon this plea, any appeal must be done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy that you have and return to the court within 42 days. If you fail to, if you choose not to appeal, you don't need to do anything with the form. The court, I'll correct it with the clerk, but the fines and costs must be paid within 56 days, or there's a 20% penalty that is added. The court will also make paying them a term or condition of your parole. Now, I heard you say a little while ago, Ms. Wheeler, that while I was talking, and that's okay, you didn't like it, you interrupt me loudly. You said you couldn't take this or couldn't do this. Rid of that attitude. That's the attitude that causes a person like you who knows well enough to go, I can't take the stresses of my life. I'm going to booze it up, get drunk, get in a car, and put people at danger because I can't take the stress. Now, yes, I'm being a little sarcastic with my tone there. Ms. Wheeler, you are the only person who can deal with it. You can't. Guys like me, or people like me in this position, are just going to keep putting you in prison. And I bet you've got people out there that love you and care about you. I also bet, because I am, family members, alcoholics, we all know that alcoholics are the best liars. And they self-pity. Don't do that. They love you. That doesn't mean you're a rotten, none of this means you're a rotten person or that you're worthless, anything like that. They love you. They're here for you. We all want you to get better. You got a lot of life to live. 59 is not that old anymore.